Please, Your Lordship. But you have beg to mention item number 6 to 9, Lordship. 6, 7, 8, 9, Lordship.
Lordship, date may be fixed, Lordship, because outside councils are there, Lordship, Lordship, 19th of August.
You are appearing on behalf of?
Appellant, Lordship.
On behalf of?
S. Setia, Lordship.
Okay, on request made on behalf of SJT, learned counsel to the appellant. When do you want?
19th of August, Lordship.
August.
Hearing that.
Yeah.
Yes,
Okay.
August you want?
Lordship, 19th.
Okay, 19th August. Okay, quite far.
How like that?
May I please, Lordship, I have one more prayer, item number 10 and 11, Lordship. With some personal difficulties, Lordship, let it be after 2 weeks, Lordship. My friend is here.
Appellant,
Appellants, my lord.
appellant,
I am for the appellant, my lord.
Okay.
Input the item.
heard Mr.
K. Mohammed.
K. Mohammed, learned counsel for the appellant. On request made by SS Roy, learned CGC.
Lordship.
When do you want?
After 2 weeks, Lordship. 3 weeks.
Let it come after 3
After
weeks.
3 weeks.
Public.
Public.
May I please, Your Lordship? With regard to item number 12, my lord.
Hmm.
My lord, this matter will take some time and it's not a regular bench, my lord. May I pray that the matter will be taken after 3 weeks, my lord?
Okay,
I've taken the consent of the other.
Sir has come.
On 27th or 29th of May, my lord. If you can- No, 27th or 29th.
Yes. It's subject to others.
Lordship, any convenient.
okay, on request made by the parties.
Let it be after.
Yes, 27th date, 27th.
You want a date fixed or?
Let it come in the, Advocate General will come. Advocate General has come, actually he was to come because I requested that I may not finish.
29.
So he didn't come. It was at my call. Therefore, your Lordship may take it by not either on the 29th of May or in the first week of June, whichever may not.
Okay. 3rd June.
Third.
Okay.
May please, Your Lordship. Lordship, with regard to item number 13, Your Lordship.
All gone.
I have a similar prayer, Your Lordship. Let it be.
On request made by Mr.
DJ Das,
DJ
Your Lordship,
Das.
for the appellant, Your Lordship.
Learned counsel for the appellant. List after?
Lordship, can it be fixed on 13th of April, May, Lordship, because we are taking consent from
Okay, 13th May.
13th of May, not sure, please.
Please, Your Lordship,
Mm.
with the consent of the other side, I would like to mention item number 2. Lordship, we have submitted the adjournment slip yesterday.
Okay. Your good name?
P. Podar
You are appearing on behalf of?
and Upadhyaya.
On request made on behalf of MSM Obadiah, learned counsel for petitioner. When do you want? After?
2 weeks, Your
After
Lordship.
2 weeks.
Much obliged.
Nothing, no more.
Item 14 of supplementary list, admission.
I'll see. Yeah, okay. Oh, I've got single mention, so.
Please, Your Lordship.
No, entry.
Yeah, 47 states.
Yes.
Well, the petitioner before your lordship, he was appointed in the year 2023 on probation basis. And the order of appointment contained 2 clauses importantly. First is that if his probation is to be extended by some further period of time, then that has to be done on recording certain reasons. And the other condition is that during the period of probation, he can be terminated at any time if his services are found not satisfactory. These are the 2 conditions, 4 and 5, which your lordships will find in the memorandum of appointment, which is at page 233,
You were serving in Akatala, isn't it?
Agartala. But the page 33, the impugned orders were issued from Silchar. Now, page 33, your lordship will find clause 4.
Then I think High Court of Tripura would have the.
Because
Well,
The
the,
appointment
How
period-
about the jurisdiction?
well, first of all, Milord, the orders were issued from Silchar.
Okay.
So cause of action had arisen within the jurisdiction of this honorable court. And otherwise also, Milord, I am coming against an order of the CAT which is at Guwahati.
No, that's fine.
even if
State
the-
city
even if
is
the-
called a seven state.
Even if the CAT is not taken as a part constituting the cause of action, Milord, particularly if your lordship will see the impugned order, which is at page 32. 32 is the typed copy, Milord. The scanned copy is at page 31. This was issued from Silchar. So part of cause of action also arises within the territorial jurisdiction of this honorable court. In fact, Milord, this order particularly is in effect by which, Milord, I have been made to deliver the charge.
Yeah.
So therefore, Milord, if your
You,
lordship,
you come to page 51 of the CAT's order.
yes,
It's construed to be from Akatala, the OA number.
that has been registered, maybe, Milord, because of their registration system is like that. Maybe because of the,
We're not very convinced. I think you should approach the Tripura High Court.
but otherwise also, if your lordship takes into account the cause of action part, Milord, because ultimately it is the cause of action which, based on which, Milord, the jurisdiction point is decided. So evidently, Milord, the 11-4 order was passed from the office of the commissioner at Silchar, assistant commissioner at Silchar. So otherwise also, Milord, the cause of action arises within the territorial. Yes, it may have been served on me at Agartala. I mean, in the state of Tripura. So the cause of action is not wholly arising in that part of the country. It also arises in this, and this order 11-4, if your lordship will kindly see page 32, well, that is very clear, Milord. It is from their office at Silchar. Page 32, your lordship may kindly see. This is the typed copy. Page 31 is the.
Let him withdraw it and approach instead of getting it dismissed here.
His appointment was from the
Yeah.
So the thing is that the authority here issuing an order will not come for jurisdiction. It's not the refusal of interim order. That's all. The matter is still pending before the central administrator.
Rather, my endeavor before the Honorable CAT was that it is one of those cases where expressly, Milord, the order has been passed in an illegal manner. Because just,
Maybe. But then we're still not convinced on the jurisdiction.
well, this order is from Silchar.
Maybe. But your appointment order, everything is from New Delhi.
No, appointment order may be from New Delhi, Milord, but my appointment was in the state of Tripura.
You have to say something.
Mr. Doso.
Yeah.
CAT is for 7 states.
Yes.
You are from Agartala. Matter was registered as Agartala. Leave that. If you come to, you're relying on page 32. Page 32 would reveal that it's just an order complying with the directions passed from New Delhi.
No, if your lordship will
You can
kindly.
come to page 32.
Yes. If your lordship will kindly come to the original order, which is issued from New Delhi, Milord,
Hmm.
that is at page 29.
This termination order.
Yes.
Then-
The termination order is at page 29. Now, the relieving order. means
That is just a consequential order to the order passed by the New Delhi. And it is written there. So that authority may have a jurisdiction over that area also, but that will not bring you within the confines of this.
So, Milord, if your lordship is taking that strict view, Milord, then in that
We are
case,
not taking a strict view. We are taking a view which is emanating from the records.
no, in that case, Milord, perhaps CAT Guwahati will also have
No,
no jurisdiction.
We will
Because
have jurisdiction because Tripura is within CAT Guwahati.
no, that is true. That is true, Milord. What I am saying, if this order, page 31 order, which has been issued from
No, your situs of appointment is in Agartala. So a cause of action is arising in Agartala. You will surely have a jurisdiction.
So cause of action is.
There'll be two places. One is the principal bench, and another one is the CAT Guwahati bench. You have chosen CAT Guwahati bench. That is fine.
No, Miller, cause of action also partly arises in the state of Assam.
Yes, my lord, we are not convinced.
Because
It's your choice.
If you want to withdraw, we'll give you liberty to approach
We
the
go and approach the appropriate Tripura, otherwise we close the matter.
then your lordship may grant me liberty to approach the court at tribunal.
Then you withdraw? Mr. S. Datta, the senior counsel, assisted by Mr. DJ Sharma, the counsel for the petition. Press for withdrawal of this writ petition with liberty to approach the appropriate forum.
Your
Okay,
lordship may indicate that the jurisdictional high court.
okay, with liberty to approach the jurisdictional high court. Stop. You are appearing for
For the respondents,
Mr.
M.K. Majumdar.
M.V. Majumdar appears for the response. Learned counsel appears for the writ petition is dismissed on withdrawal with liberty expressed.
Obliged.
One of Delhi list.
Wait, please, Mr. Lawson. Well, 2 weeks time may be granted for filing affidavit in reply.
You filed your reply, isn't it?
Well, they have filed affidavit in opposition.
Okay. Mr.
HP Gwala.
H.B. Gwala, learned counsel for the petitioner is allowed 2 weeks time to file reply to the counter filed by the respondents. List up to 2 weeks.
Obliged.
3. Hearing.
Oh. Health. What's his name? Bora, you're supposed to file an affidavit, isn't it? Have you filed it?
Not yet.
Communication, my lord, because the department is collecting information from other organizations like NHF and they are not getting the report, so they have sought for some time. We have to file the affidavit filed by the.
How much time do you require?
Today morning I have received this paper, it has been issued today, my lord, 1 month time.
1 month is too long, isn't
Too
it?
long.
I'll give you 3 weeks.
Yes.
But the petition in person. Mr. D. Bora, then it's council. Then it's standing council, health department is allowed another 3 weeks time to file the latest factual report. List after 3 weeks.
Your lordship may fix up a date because 27 June is the last working day.
Give a date after 3 weeks. Oh. It's a DP Bora, huh?
22nd.
22nd
May.
May.
22nd May. Obliged.
4.
I should kindly peruse the last order by way of which my learned friend was required to get certain instructions on the matter.
Well, the order has been complied with. The policy has been framed, my lord. It has been notified also. The order is, my lord, 7/11/23. That was the main order. I will
Lordship,
file one short affidavit, my lord, to bring this.
let him bring the policy by on record by way of an affidavit. And the only concern which the petitioners would have at this point of time would be the clause number 9 of this particular policy. It specifically says, if I may just apprise your lordships, this policy shall be applicable only in cases of unnatural death of inmates occurring on or after the date of notification of this policy. Now, that would naturally not give any benefit to the to the cause
Correct.
which we had raised.
Okay,
before-
let him
before-
come
Let
by
let
written,
him
then,
come up by way of an affidavit, then perhaps your lordship will take. note of
Mr.
that.
B. Gogoi, Learned Standing Council Health Department submits that the governor of Assam has formulated the policy for payment of compensation to victims of the prisoners who have suffered unnatural death by way of a notification dated
Well, it is dated 27
2024. He accordingly prays for how much time?
Well,
1 week?
Yes, 1 week.
Prays for a week's time to bring the said notification by way of an affidavit. Praise the Lord. At least after 1 week.
Deeply obliged. Lordship may kindly fix a date subject to your lordship's convenience.
Date. What to?
13th. 13th of May,
Deeply obliged.
5.
It's the last matter.
No, it is
We can take up.
202.
Some other bench. List this case before any other bench without one of us written by the justice. You can.
I'm sorry to mention item 5.
You can't take it.
Yes,
We have already passed orders before any other bench.
without only. Without only.
One of daily list hearing.
Lordship.
Hmm.
Under the lordship, I am relying the full bench judgment, lordship.
Hmm.
Now I am another 2 judgments remain. That's the FI lordship. Basic thing is that lordship, the petitioner name is not reflected in the 354 final seniority list lordship, which was prepared as per the office memorandum dated 17/7/2004 lordship.
Hmm.
That was prepared lordship on the basis of the direction issued by this honorable court lordship. And in that particular list, provisional list lordship was published. In that particular list, just I'm reiterated lordship, that part, his name was reflected with a remark column that lordship, no government concurrence is there lordship. In the particular college lordship, in the Department of English and along with other departments lordship, there is a concurrence is given by the government lordship on the basis of the recommendations and affiliations of the Guwahati University. In every department, he post is there lordship. Petitioner hold the post of 4th post, it is admitted position lordship. One of the claim is that petitioner that after the resignation of the HOD lordship, the 3rd post remain vacant. So he should be treated as a working against the lordship, that sanction post lordship. And our lordship stand is that lordship, as per the statutory prescription prescribed by the statute lordship, 2005 Act and 2010 rules lordship.
Hmm.
If any vacancy arises lordship during the resignations or lordship unnecessary circumstances lordship, then it should go for the lordship direct recruitment. That is the issue. And I'm relying the full bench judgment lordship. Full bench judgment is that as because there is a dispute between the honorable 2 division benches lordship regarding cut-off date, which should be lordship adjusted. Then finally the honorable full bench says that the persons who were appointed under the 17/7/2004 OM and who have joined prior to 17/7/2004 lordship, whose name is reflected, they are in the considered zone lordship. And that was further elaborated lordship in the division bench judgment lordship, 2018 5 GLT 801 lordship. I have supplied the copy lordship. Now that I have to find it. 2018 5 GLT 801 lordship. That day I have supplied 3 judgment lordship.
Where are those judgments?
Then lordship,
Oh, Yeah.
Here, Lordship, I am relying paragraph 6, 7, 8, and 9, Lordship. Here, in this case, Lordship, the particular petitioner, Lordship, Abdul Wahid, Lordship, he was appointed by the College Authority against the non-sanctioned post, Lordship, prior to 17/7/2004, Lordship. Exactly in the similar situation with the petitioner. 17/7, before 17/7/2004, he was appointed, Lordship, but his name was not reflected in the Lordship final seniority list of 354. That's why Honorable Court negated his claim, Lordship. So I'm relying paragraph 6, 7, 8, and 9, Lordship. Paragraph 6, Lordship. As referred to above, the case of appellant Abdul Wahid for adjustment/regulation is on the basis of the apposite office memorandum dated 17/7/2004. A perusal of the said OM, which is enclosed at Annexure 7, it is seen that same was issued by the Government of Assam in the Higher Education Department as a one-time measure for regularizing the service of more than 300 college teachers who were found to be serviced in different degree colleges under the deficit system of grants in aid since the year 1989 against non-sanctioned posts. By the said OM, the procedure modalities were prescribed for adjustment of the services of the identified college teachers working without sanctioned posts. The said office memorandum was purpose specific, and once the objective of the OM was achieved, another office memorandum dated 12/10/2004 was issued, stipulating that no college under the deficit grants in aid system should engage any persons as a lecturers where no sanctioned posts exist for the purpose. Then, Lordship, paragraph 7. The learned single judge had duly taken note of the OM dated 17/7/2004 as well as the full bench decision of this court in Mizanur Rahman vs. State of Assam 2012 1 GLT 520, wherein the rationale for the issuance of the OM dated 17/7/2004 was considered. On our own, we have also perused the full bench decision and find that the OM dated 17/7/2004 was issued to address the problem of an identified group of lecturers as a one-time measures. In the said case, it was noticed that way back in the year 1952, the Government of Assam had bought 52 colleges under the deficit grants in aid system. Thereafter, the state stopped sanctioning new posts of lecturers in colleges, as a result of which the lecturers serving against non-sanctioned posts were unable to have their service regularized. This led to filing the writ petitions before this court pursuant to the order of this court, and since the government was not in a position to sanction any new post, a cabinet memorandum was prepared on 25/3/2004 to deal with the issue. In the exercise so initiated, the cabinet memorandum is list of about 322 vacant posts in different deficit colleges was prepared. The cabinet approved the same on 19/6/2004, whereafter the OM dated 17/7/2004 was issued for adjusting the service of about 300 college lecturers working against non-sanctioned posts. The full bench held that those lecturers whose cases were not under consideration at the time when the cabinet decision was taken in 9/6/2004, they cannot claim the benefit of OM dated 17/7/2004, inasmuch as the procedure of regularization envisaged in OM dated 17/7/2004 was intended to take care of only about 300 identified college lecturers and not those who were subsequently appointed so and so. In the instant case, although the appellant Abdul Wahid was appointed a non-sanctioned post on 2/7/2004, that is prior to issuance of the OM dated 17/7/2004, exactly similar case, he cannot claim the benefit following out of the said office memorandum, as the same was purpose specific and was intended to address the problems/issues with regard to an identified group of lecturers. The appellant was not one among the group as held by the full bench referred above. The OM dated 17/7/2004 was not intended to be a perennial source for regularization of services of lecturers. In this respect, the appellant Abdul Wahid cannot claim and or is not entitled to seek the shelter of OM dated 17/7/2004 for adjustment regulation of his service. Over and above, when the appropriate statutory act and rules clearly lays down, that is, Lordship, 2005 Act and 2010 rules, Lordship, The procedure while making appointment to the post of lecturer slash assistant professor, the concerned authorities are statutorily mandated to follow the procedure and are not permitted to seek refuse in the government office memorandum to give any benefit of adjustment or regulation to a college lecturers working as non-sanctioned post. In this respect, also the OM dated 17/7/2004 cannot come to the aid of the appellant, although he was appointed against non-sanctioned post at Kharupetia College prior to 17/7/2004 also. We find no infirmity in the findings of the decision of the learned single judge, the present appeal being devoid of merit, stand accord. That is the order passed by the Honorable Division Bench, Lordship. Although in that case, Lordship, the particular persons were appointed prior to 17/7/2004, Lordship, his name was not reflected in the final seniority list, so Honorable Court negated his claim, and Honorable Court observed that although his appointment is 2/7/2004, he cannot claim regularization or adjustment on the basis of the OM dated 17/7/2004, which was a purpose specific for the redressal the grievance of a Lordship specified group of teachers. That is the findings of the Honorable Division Bench, Lordship.
Let us see the 2005 Act. again.
Act, Lordship. Because reason.
Correct.
Not
That was page
Lordship, it is starts from Lordship, page number 490, Lordship. It's a act, Lordship, and on the basis of act, Lordship, Rule 12 is the Lordship rule making power, Lordship. Rule 12 is Lordship 495, page 495.
section.
Rule section 12, Lordship. Section 12 is Lordship 495, Lordship.
Then the rules.
It's a rule making power, Lordship.
The next page is the rules.
No, next page is the rules, Lordship. On the basis of that, Lordship, 496, in exercise of powers conferred under subsection 1 of section 12 of the Assam College Employees Provincialization Act 2005, the Governor of Assam is hereby pleased to make the following rules for carrying out the purpose of the said act. And the rule, Lordship, the method of recruitment is Rule 5, Lordship.
Yeah.
Rule 5 is method of recruitment in respect of the Lordship lecturers. Rule 5.2, Lordship, lecturers and professors, Lordship. Assistant professors, Lordship. Rule 5.2, 497, page number 497. Lordship. It's a direct recruitment, Lordship. For the purpose of lecturers, librarian, appointment shall be made by direct recruitment with prescribed qualification to open advertisement into leading dailies at least in 2 consecutive issues, Lordship.
Okay.
Then, Lordship, Rule 5.7, Lordship. In all these cases, the governing body shall conduct the selection process and recommend it to the director who shall issue the order of appointment. Then, Lordship, 7. It's a direct recruitment, Lordship. All the appointments either by direct recruitment or by promotion. Promotion means, Lordship, CS promotion, cash promotion, Lordship. After after entered the service as a direct recruitment, there is a provision for, Lordship, CS, career advancement scheme, Lordship. That is the promotion, Lordship. And or by way of promotion shall be made by director on the basis of the recommendation of the governing body, based on the recommendation of the selection committee / departmental promotion committee duly constituted, Lordship. The director shall communicate his order within 30 days. Then, Lordship, C, the selection committee may hold such test of interview for all posts as may be considered necessary. For the post which UGC has prescribed norms, no candidate shall be recruited without having the required norms, Lordship. All fresh appointments shall be made on receipt of the police verification. That is the procedure, Lordship. And there is no provisions or prescription in these rules as well as acts, Lordship, regarding adjustments or regularization, Lordship. There is no provision. Then, my lord, other single bench judgment, Lordship. Various judgment is there, Lordship, single bench. Just I am relying one judgment, Lordship. Its WBC is 712417 Lordship.
WBC.
7124 2000, it is there Lordship.
Yes.
Lordship, Lordship. It's order dated 26/2022 Lordship. My lord, may starts from page 3 Lordship. Other texts are there, page 3 Lordship. Just I read out Lordship. Page 3 onwards Lordship. The petitioner is seeking regulation of services under the provisions of the State Office Memorandum dated 17/7/2004. The state government in the higher education department as a lecturers in Rangasai College, Majuli, that fell vacant on 10/6/2017 as one of Dr. Pikumoni Setia, Assistant Professor, Department of Assamese, resigned from his post and joined another college, namely Hemchandra Dev Goswami College, Nitai Pukuri, Shivsagar. Here also, Lordship, petitioners seeking the regulation against the Lordship post which was resigned by the SOD Lordship. Here in this case, in the case which is going on Lordship, in this case, one of the claim of the petitioner is that as because SOD is resigned from the post, so he should be considered under the OM in that particular post. And in this case also, Lordship, one of the lecturers, assistant professors was resigned from the post to Lordship join another college. Then the claim for the petitioner was there, he should be regularized in that particular post, Lordship. Then Lordship, petitioner also placed before the court that he was passed the state level eligibility test for lectureship in the year 2014 held on December 2013. He also stated that pursuant to the government circular dated so and so relating to the information of non-sanctioned teachers appointed prior to 12/10/2004 for regulation of service of teachers, the college concerned under the government office memorandum dated so and so, the governing body of the respondent college recommended the name of the petitioner in its meeting held on so and so for consideration for regulation of his service against the vacant sanctioned post of the said college, Lordship. Accordingly, the respondent college authorities on 23/9/2014 submitted all the relevant details for consideration of his case for regulation against vacant sanctioned post of lecturers in Assamese in the said Rangasai College, Majuli, before the Director of Higher Education, Assam. As the respondent authorities did not consider the case of the petitioner for a regulation against the vacant sanctioned post of lecturers in Assamese in the said Rangasai College, Majuli, in spite of recommendations submitted by the governing body of the said college, the petitioner preferred this writ petition. Office memorandum of the state government in the higher education department dated 17/7/2004 relates to only those lecturers who were appointed against such non-sanctioned posts on or before so and so, and it was issued for a specific purpose as a number of such lecturers brought under the grants in age system were left out due to the non-availability of the sanctioned post, and they continued to serve without any sanctioned post. In the case in hand, the petitioner, after obtaining master's degrees, was appointed on so and so, months after coming into the post of the office memorandum dated so and so. Though the petitioner was initially appointed by the managing committee of the respondent college on 29/2004 Lordship. But at that point of time, petitioner was not a master degree holder as such. That appointment and of the time did not have to be eligibility to the post of lecturers or degree college. Further, the name of the, my lord may kindly mark it. Further, the name of the petitioner was not incorporated in the list of non-sanctioned teachers consisting of 354 numbers in terms of the decision of this court issued on 14/5/2009 passed in so and so. That final list was reflected, Lordship. That petitioner's name was not reflected there, Lordship. Further, a full bench of this court in the case of Mizanur Rahman versus State of Assam reported in so and so clarified that benefit of the office memorandum dated so and so of the college teachers of higher education department is available only those lecturers who were appointed so and so, not others, Lordship. Further, the division bench of this court in the Abdul Wahid versus so and so involved in the issue of lecturers that was incorporated, whole paragraph is incorporated, Lordship. Then my lord may in page 5 last 2 paragraphs, Lordship, that is there. On the basis of that, his claim was negated, Lordship. As because Lordship petitioner's name was not reflected in the final seniority list, Lordship, he is not under the considered June, Lordship. Now, Lordship, I am relying our affidavit, Lordship. Affidavit, I am relying paragraph 5 onwards, Lordship.
Para,
Paragraph 5 onwards, Lordship. Page 3, Lordship. So, running page.
just no run.
Running page
126.
126, Lordship. 126, Lordship.
Yeah, affidavit in opposition.
Affidavit in opposition, Lord. Lordship, affidavit was filed by Lordship Gitimoni Pukon, Lordship. Respondent number 3, Lordship.
Huh.
Respondent number 3, Lordship. Internal page 3, Lordship. I am not finding a running page, Lordship. Internal page 3, Lordship.
Yes.
Paragraph 5 onwards, Lordship. That with regard to the statement made in paragraph 6 of the writ petition, the deponent begs to state that a provisional seniority list of lecturers working against non-sanctioned post was published in Assam Tribune dated 08/1/2010 and 09/1/2010 by the Director of Higher Education Assam, by letter dated so and so, as per the direction of the Honorable Court dated so and so, passed in so and so, for general information to all concerned and inviting objection, if any, in the provisional seniority list. The name of the petitioner has been figured in the provisional seniority list and CL number 305, Lordship, and against his name there was given the remark that no government concurrence, Lordship. As per the terms and conditions laid down in the government office memorandum dated so and so, Lordship, after final verification, a final seniority list of 354 numbers of teachers appointed by different colleges against non-sanctioned post was published on 22/4/2010, where the name of the petitioner did not figure because the petitioner working against a non-sanctioned post without having the government concurrence, Lordship. My Lord, may kindly mark it. The petitioner do not stand in equal footing with others, as the petitioner was appointed against non-sanctioned post, that too where no government concurrence to the post held by the petitioner, Lordship. Then, Lordship, 6. That with regard to the statement made in paragraph 7 of the writ petitions, the deponent states that after published of the final seniority list on so and so, some non-sanctioned teachers whose names were not included in the provisional list and final list was applied before the government as well as the Director of Higher Education, etc., for inclusion of their names in the list. Accordingly, list of the petitions / persons of this category has been forwarded to the government for necessary order from time to time. The name of the petitioner was also included in the said type of list and sent to the government for necessary information and instruction in this regard. It is to be mentioned here that final list of 354 numbers of non-sanctioned teachers was one-time exercise for by following the terms and conditions of the office memorandum dated 17/7/2004, Lordship. Exactly the line which was delivered by the Honorable High Court, Lordship. That with regard to the statement made in paragraph 8 of the writ petition, the deponent states that West Goalpara College was accorded concurrence in English general course with effect from 94/95 by government letter dated so and so, Lordship, and there are 3 numbers of sanctioned post of assistant professor, Department of English in West Goalpara College for general courses, Lordship. There are 3 numbers of posts. There is no dispute, Lordship. Petitioner in the 4th post, Lordship. That with regard to the statement made in paragraph 9, Lordship, so paragraph so and so, Lordship, the writ petitions, the deponent begs to state that Government of Assam Higher Education Department has issued an office memorandum, Bhait Nong so and adopted a policy to accommodate the teachers working against the non-sanctioned post with the following procedural modalities, Lordship. Lordship has already gone through it, Lordship. 4A, 4B, Lordship. Then, Lordship, 4C is there, Lordship, next page, and 4D, Lordship. The whole office memorandum is, Lordship, incorporated here, the relevant portion, Lordship.
Okay.
Lordship. Then Lordship, page 8, last two paragraph, Lordship. Pursuant to the government office memorandum dated so and so, after final verification, a list of 354 numbers of teachers appointed by different colleges against non-sanctioned posts have been prepared. After obtaining government approval, the service of 187 numbers of lecturers were regularized in a piecemeal manner from time to time, as there was no vacant sanctioned post in the particular college, and vacant posts were to be withdrawn in another college as per clause 4C of the office memorandum dated 17/7/2004. That was earlier I have indicated, Lordship. There are three types, Lordship. One is the vacant post in that particular department itself, Lordship. One is one category, and another is the category, Lordship, vacant post of the other department of the same college, and other is the category, Lordship, vacant post of the other colleges, Lordship, where the post is not required. That modalities is there, Lordship. If the college department itself is a vacant post, then if the person's name is reflected in the, Lordship, that particular seniority list, it should be adjusted from the department itself. If the college has to the other department the vacant post, Lordship, if there is no requirement of that particular post, Lordship, then that post should be accommodated for the persons whose name is reflected in the, Lordship, that particular seniority list. And the last category is that, Lordship, if the college where the person's name is reflected in the final seniority list, no sanction post is there, vacant post is there. If, Lordship, any vacant post is there in any provincialized college in the state of Assam, Lordship, if that particular colleges, that particular post is, there is no requirement of that particular post, then the government can withdraw the post from that college to adjust the Y college post, Lordship. That is the one of the modalities, Lordship. Then, Lordship, in order to complete the entire regulation process of the remaining 167 numbers out of 354 numbers of the teachers called for hearing, and only 123 numbers were present and submitted documents. Out of 123 numbers of non-sanctioned teachers, 99 numbers of non-sanctioned teachers were considered for regulation of their services, and remaining 24 numbers of non-sanctioned teachers were not recommended due to the various reasons, including pending court cases, Lordship. Out of 354, Lordship, now 24 numbers of teachers we have to adjust, Lordship. Others were adjusted, Lordship. 24 is remaining due to the court cases and other reasons also, Lordship. Then, Lordship, in terms of the government office memorandum dated 17/7/2004, the government as well as the Director of Higher Education Assam has decided to block the vacant post of assistant professor of the respective colleges where non-sanctioned post of 354 numbers of list were working and yet to be adjusted or regularized of their services. The following incumbents were working in non-sanctioned post in the West Goalpara College as per the 354 numbers of list. That 4 persons are still their regulation will be done, Lord. It is, Lordship, Gagan Chandra Nath in the Geography Department, 313, Minhasuddin Ahmed, 314, and Hafizur Rahman, 323, and Nitamani Nath, 324, Lordship. Nitamani Nath was adjusted, Lordship. That post was withdrawn from Guwahati Commerce College, Lordship. That C category, Lordship. That post was withdrawn, Lordship. Subsequently, her service was adjusted. The petitioner has been working as non-sanctioned lecturers in the Department of English in West Goalpara College. The principal of the college was submitted proposal dated so and so to this Directorate for regulation of his service against the vacant post. But the director, next page, Lordship. But the Director of Height letter dated so and so has rejected the proposal on the ground that the name of the petitioner is not enlisted in the 354 numbers of non-sanctioned teachers list. Further, there is no provisions for regulation of the services of lecturers appointed by the college authority against non-sanctioned posts, non-existent posts. In the final seniority list, the name of the petitioner is not figured, Lordship. Then paragraph 10, Lordship. Paragraph 10 is basically the judgment which was pronounced by our High Court. That is, full bench judgment is reiterated, paragraph 12, Lordship. Paragraph 10, Lordship. Under the above, Lordship, facts and circumstances, Lordship, and the law laid down by the Honorable High Court in the full bench, Lordship, the petitioner's case is not in the considered zone, Lordship. He is not entitled for regulation or adjustment, Lordship, under the 17/7/2004 OM, Lordship, as there is no procedure, modalities, or prescription prescribed by the Statute, Lordship, 2005 Act, and 2010 rules regarding adjustment and regulation of the non-sanctioned teachers who is working against a particular lordship subject. All the requirements lordship after 2005 Act and coming into force of 2010 rules lordship, they are by way of the direct recruitment lordship. By complying the principles of the Constitution's lordship, it should be the direct recruitment lordship. There is equal opportunities there lordship. And the case of the petition, one of the case of the petitioner is that just I sum up lordship. He says that he should be adjusted lordship, the particular vacant post which was alleged in the 2017 lordship. That should be go to the lordship direct recruitment. And the persons who were mentioned in the petition, the particular 2 persons' name was reflected, that they also are indicated. They are appearing in the lordship selection process. They are as per the 2010 rules, they were accommodated. And one of the cases the petitioner is that the persons who were not figured in the lordship 17/7/2004 OMS was adjusted. It is admitted fact that lordship, we have also admitted lordship, adjustment was done lordship. By violating the law of the Honorable High Court lordship, something was done, some wrong was done. That's why lordship, the persons is suffering now lordship. So many proceedings is going on against that person, and he was removed from the department also lordship. That is the reasons lordship. And so many, and that cannot be a ground for regulation lordship. The Honorable Supreme Court time and again reiterated that lordship, even the wrong order was passed by the Honorable Court in the judicial forum also lordship, that cannot be treated as a precedence to lordship, supplement it lordship. If wrong order passed by the executive lordship, that cannot be lordship. And Muthu Kumar judgment, I am relying that judgment, I just stand by it lordship. Paragraph 24 the judgment of Muthu Kumar lordship.
What?
Just time read it and lordship, I will hand over it lordship.
Give me this.
No, I'll read, I'll supply the copy lordship. I just read it lordship. 2022 0 Supreme SC 135. 2022 0 Supreme SC 135 lordship. Even lordship, it was in SSC also, it was lordship reported. I have not the SSC copy today lordship. Otherwise, I have the SSC copy also.
Page
Lordship 135. I'll hand over it lordship. Just I read it lordship. Paragraph 24 lordship. A principle axiomatic in the country's constitutional law is that there is no negative equality. In other words, if there has been a benefit or advantage conferred on one or a set of people without legal basis or justification, that benefits cannot multiply or by relied upon a principles of parity or equality. In Basavaraj versus another versus special land acquisition officers reported in so, this court ruled that paragraph 8 lordship, that particular judgment is quoted lordship. It is a settled legal proposition of law that Articles 14 of the Constitution is not meant to perpetuate illegality or fraud. Even by extending the wrong decision made by other cases, the said provisions does not envisage negative equality lordship, but has only a positive aspect. Thus, if some other similarly situated persons have been granted some relief, benefit inadvertently or by mistake, such an order does not confer any legal right on others to get the same relief as well. If a wrong is committed in earlier case, it cannot be perpetuated. Other decisions have been enunciated by or applied these principles. Other cases is referred lordship. If an illegality and irregularity has been committed in favor of an individual, of a group of individuals, or a wrong order has been passed by a judicial forum, others cannot invoke the jurisdiction of the higher or superior court for repeating or multiplying the same irregularity or illegality, or for passing a similarly wrong order. A wrong order or decision in favor of any particular party does not entitle any other party or to claim benefit on the basis of the wrong decision. So, lordship, but our case is very clear, lordship. Already division bench has decided. Even the persons was appointed prior to 17/7/2004 lordship. If his name is not reflected, then also he is not entitled for adjustment or regulation. Paragraph 24, last page, lordship. Last page, lordship.
Okay.
So this is my submission, lordship. Oblige, lordship.
R10.
তোমালোকে কিবা ক'বা?
Your 6, 7,
8, 6, 7, 8, and 9, my lord.
6, 7, 8, 9. Yeah. This respondent 10 also, isn't that
10, my lord.
Shikta?
Yes, ma'am.
Who's representing 10?
Mr. Vijay Puppan.
Oh, he's not here. Just see if he's around. Otherwise, there's no point in proceeding further.
Maybe. I'm hearing on.
Let us see if PG Fukan is
Yes,
there.
yes,
If that's
yes.
not there, then we'll hear you on a different date. Otherwise, there's no point. No, yours is complete.
But I have to make the reply.
I'm
No,
relaxed.
no, I'll give you time. Don't
Well.
worry. Let us hear the respondents
Well,
first. After
well,
that, you give your.
well.
Maybe some water locking is there. Then we can fix a date.
It's what date, ma'am.
Probably don't think he was the.
Yes,
নাম তো show করিছে না নাই?
Personal problem in.
okay. But AK Shikta, let us counsel for the petition.
তাহলে AR Sikdar.
I'm sorry, AR Shikta, let the counsel. Also heard Mr. K. Gugoi, Learned Standing Council Higher Education. And Mr. AK Azad, Learned Council for the respondents, 6, 7, 8, and 9. Stop. None appears for the respondent number 10. Heard in part. When do you want?
Any day as per lordships.
When can he come? Can you just ask him? List the matter on. Then get a date from him and then we'll list.
Next week, any day lordship.
Let him get a date.
সুবিধা নাই নেক্সট উইক মই আছো মেয়ের 10 তারিখে নাই মেয়ের 10 তারিখে না থাকি মে 10 11 12 12 তারিখও কোন কথা
Madam, on 13, I will inform him lordship. 13.
Okay.
I'll inform. 13. Not it.
Okay.
Smile.
13.
Well, it will be better to on
It's a hearing day.
12 to
15 mallet 15
15 bonus, na?
Yeah,
Also,
15 bonus.
March, March, April, May. First May, my lord.
First May. Yes, first of May is the court আছে yes I'm ready on first May.
I know the difficulty, lordship.
I have no difficulty. My lord, Suika name, pieces Suika name may be reflected, my lord.
No, his name is that PG Fukan.
Please, lovely.
2, 3, 4, and 5.
Oh. This was a long printing material.
My appraisal.
Oh.
In all these petition related to pensioner, non-receiver pensioner benefit. And to refreshing the
Yeah.
case, they are all petitioners
I mean, in the short, I am representing the Lordship can take the item number 4, which earlier has been taken.
Item,
Item
Item
4, the Thireshwari Bahoy. Case of Thireshwari Bahoy.
that's item 3,
Yes, yes.
4012.
4. Item number 4, that is, that one, Lordship, earlier, Lordship take the,
No.
take the,
Prova Chitia.
yes. Thireshwari Bahoy.
Thirishwari Bahui, that is item 3.
4012. Before, I am apprehending what is the case in a short, for your Lordship convenience. All petitioners are appointed as a assistant teacher in different school. Thereafter, on 1992, their service were terminated by the authority without following the due process of law. They opposed this honorable court. Honorable court, after hearing these parties, pleased to set aside the termination order and reinstated them in their post. There is a caveat in the order that if they found to be irregular, if they find to be irregular, they can put on notice. They can find the respondent can have a right to do due process. They can be process. They can take action. Long
Disciplinary
but period of time 25 years, the government have not taken any action. And rather, during the service period, they have sent to the training by the government, basic training which is required for the teacher of elementary education, and they have completed their successfully completed their training, and they are receiving their regular pay of scale with time to time increment in time to time. When the matter is going like this, on 2007, suddenly all teachers, they were salary are stopped. On the question of they are appointing and on the existing post or that. The petitioner opposed this honorable court. The honorable court, after hearing the parties at length, allowed the petition. And that nothing can be done because the earlier orders still exist. They are reinstated, they are in service, they are rendering the service, you cannot stop their salary. Thereafter, the salary, even after the government filed a review petition on that, that is also dismissed by the court. Petitioners rendering their service in their respective posted, and the time elapsed, and therefore after completion of their tenure, almost all our petitioners are 25 years in service, they are retired. But their GPF amount, their retirement benefit which are required to be given is not disbursed. Therefore, the petitioner opposed this court for direction to release it because they cannot withhold it because as the situation they are working there, they are in the admitted position, they are acquired the status of a government servant. If a person is working at 25 hours at the end of the term, you cannot say that their initial appointment or whatever, you cannot say that. And that is already been given by the court, and you have not, you waive your right. Now you are stopped to do anything on that. The government filed an affidavit. They said there is an office cabinet memorandum, and on cabinet memorandum, these teachers were giving a different category, and petitioner of this paragraph is entitled for the post of accommodating post, but they could not be given because they are already been retired. That ends their stand. And they are non-existent, but therefore we have not giving the salary. That is their point. My submission before your lordship that if a person is working at 25 years service all document of before election, I am after the completion of it, I will give a written of this gist of argument or this before this court. Now, after executing the 25 years of service, you now cannot say that your appointment was irregular because the court have to come in the two, 3 times. The direction even given to them. If you have the irregular, you may take action, but you did not take any action. Rather, you send me to the training, teachers training, and I am successfully passed. And 2 of the petitioners, even I will indicate in their service is also confirmed. Now, at this stage, after going through this period of lapse of time, being a government, you cannot say the recent judgment of this, I will place that if a person is in that case, there's some ad hoc employees going for the years together, they are denying Gujarat case, denying the pension, and they go before the court, Supreme Court deal with the matter and said that what they said to take a service. I'm just quoting that. I will giving the, all the judgment to take the service continuous for 30 years. Thereafter, to contend that employee who rendered 30 years continuous service shall not receive pension is nothing but unreasonable. As a welfare state, they said ought to have not taken such stand. In this case, their service, they are ad hoc appointee. Even that court says. Here the case, they are appointed, they may be irregular, there may be, but they have not taken any action. The court interfered the matter. In court instance, I was stated. I have enacted judgment in my petition, Lordship will kindly have a look on that.
Anyway, you finish the facts first. After that, we'll go to the judgment.
Then Lordship, if Lordship convenient, if I am I have already been submitted before this court, what is they said in their affidavit, what petitioners in all legal, I have make a compilation.
Okay.
And the different judgment from the Deakin London, the pensionary case, from the recent judgment of this honorable court, I have annexed. I am passing this to Lordship. And if Lordship go to the next, they fix, then we can finish it. Then there's a simple only parameter is very.
You give him a copy also?
Oh yes, sure. I will give a copy. I will give a copy. You are not required because you are the accountant general. Their party is already been over. GPF. They are only concerned with the GPF, and GPF already been released.
Okay, then we'll see this and come.
Yes.
Huh? You can go through that.
I am very minutely. I have given all the things, but
Sharma, you can also make a.
No, I will make one.
Heard Mr. P.B. Barol in the council of the petition, as well as P.N. Sharma, Leonard Standing Council, Elementary Education Department, and Miss Finance is there. MS R.M. Barua, Leonard Standing Council, Finance Department, and Mr. D. Bhattacharjee, Leonard Standing Council, Accountant General. Huh? When do you want?
Lordship convenience. I'm not doing
The Sharma is a busy man, so we'll go according to your date. May I prefer Lordship 20th, May? 20, Lordship.
Lordship convenient. Lordship,
I have some difficult. Please on 20 May. Lordship. In the meantime, I will prepare the.
Two items there, yeah, I'll give it. One more thing, my friend has agreed that TT has done it. So I feel that if TT has done its part, then my presence may not play out ages maybe that will that way accepting that. This is my oral submission. If he agrees to it, then
what?
You are appearing in WBC?
two items. 65 of 23, track 2,
And
and item 5, 1917 of 20.
and who's the other one?
There are
AK Talukdar. RK Talukdar, standing accountant general for WBC 4012 2023 and 4013 2023, correct? Finish.